shorter than the other speakers. Just a bit about myself. I'm 48 years old. I have 2 sons. My eldest son is 18 and my youngest son turns 15 today. We had his birthday celebrations yesterday. I suppose as a member of the Liberal Party, very committed to the idea of family. My own parents celebrate their 60th wedding anniversary today. And the issue of surrogacy and children who are so wanted that their parents are literally walking to the ends of the earth to make that happen, to me is, as Robert Menzies would have said, or did say, the instinct to build a family is the most noble instinct in our civilisation. And it is one that the Liberal Party is sworn to support, and it's one of the reasons I'm a member of the Liberal Party in a philosophical sense. So I suppose I'd like to begin today by thanking you and congratulating you for your commitment to children and to citizenship and to building this country. And I would have to say, from personal experience, people who do undertake this journey end up in actually a better place than if it all happens so easily or if it all happens by accident. To actually have a child that is that wanted, I think, is the most special thing imaginable. So I thank you for that. Secondly, I feel I ought to apologise on behalf of the New South Wales Parliament for the terrible mess that we made of this issue in October of 2010. Now, I understand that David Shoebridge has spoken to you about the chaos that was underway on the floor of the House that day. Can I also say that I now know a lot more about the issue today than I did at the time. There was an awful lot of legislation going through the Parliament at the time, and members were very confused on a whole range of fronts over some very difficult issues, including, in my case, I was responsible for solar bonus legislation, which, if you're from New South Wales, has been a complete schmozzle of another kind. But as the opposition person responsible for that, I was totally derailed by other business at the time. So, as I say, I have put a lot of effort into this issue subsequently. I'm quite pleased, obviously, with the way that I voted on the day. I can't claim special credit because there was so much confusion going on. And I would say, on behalf of my colleagues, it was a very confronting thing, I guess, to be sitting on one side of the House, the only Liberal looking physically at every single one of my colleagues on the other side of the House. But they certainly bore me no ill will by doing it, simply as a measure of how difficult this issue was in terms of people not understanding what was happening. Now look, I just thought, even though David has spoken to you, I might just quickly recap on how the legislation came about. There was a committee, a standing committee on law and justice in New South Wales, which reported in May of 2009. And I think the title of the report is very important. It's called Legislation on Altruistic Surrogacy in New South Wales. The report was never intended to deal with commercial surrogacy. And if I may just read briefly from the Chair's introduction, Christine Robertson, who's no longer a Member of Parliament, but she's a Labor Member of Parliament who I have great admiration for. But just in the forward, if I may just briefly quote, it says, "The practice of surrogacy, altruistic or commercial, is a contentious and divisive one that gives rise to diverse and often irreconcilable views. Furthermore, these views are typically grounded in deeply held convictions about reproduction and family formation and legal, religious and ethical standpoints." This is very unfortunate that there are a whole lot of issues that have nothing to do with surrogacy that constantly keep diving in and making the thing more complex than it needs to be. I would like at the outset to acknowledge this diversity of views and the fact that the committee itself is divided with regard to the views of its members. And it's unfortunately, whatever position the government takes, it will be unpopular with some parties. She refers to all the legislation and the fact that there's very limited regulation and that it does need to be addressed. And the report was clear that the practice of people having to go through the adoption process in a surrogacy-related birth was completely stupid and needed to be addressed, which is why we had this report and this legislation. But this is the key sentence. There was a consensus amongst inquiry participants in the committee that the best interests of the child were the paramount consideration in relation to the practice of surrogacy. And in this respect, the committee came to the view that its primary obligation is to protect the best interests of children who are born through surrogacy arrangements, by removing, where possible, any disadvantage that may currently exist for them by virtue of being born through such an arrangement. Now, for me, that is, in this detailed report, the whole key to the issue of surrogacy, is that we take the view that we're wanting to serve the best interests of the children. What happened in the New South Wales Parliament, and Linda Burney, you may be aware, as the first Aboriginal woman to be made a minister in the New South Wales Parliament. There's a lot of emotion surrounding that. She has a lot of her own issues in terms of stolen generations and cultural issues that I think have a great kind of bearing on her thinking. And unfortunately, because she was a minister, and unfortunately because the whole amendment was proposed so late, it came up in the Cabinet of the Labor Party. There's a lot of sympathy for Linda Burney. The issue went through Cabinet. Once that occurred, it then went through caucus. It came up literally with no notice in the lower house one day, and the very next morning the upper house was trying to deal with this issue. So there was no consideration whatsoever given to the proposal. It had nothing to do with the report of the upper house, and many members were very upset. And unfortunately, because of the hijacking of the process, it just flew through. And it's a situation that people didn't really want to return to. We then had a state election, and I suppose I'm now talking to Sam and to Richard about how we can revive the matter and have it more thoughtfully addressed, and I believe hopefully rectified in New South Wales. So, thank you. Look, I feel embarrassed to be here. I feel embarrassed that this situation has been inflicted on so many families. And it was a great wrong, and we're hoping that sensitively behind the scenes. But one of the issues that we have is that there are people who oppose the issue for ideological reasons, which have got just nothing to do with fertility and families. I mean, there might be people who are upset about homosexual relations. There's a whole lot of other issues, and my role really is to try and extract those issues out of the problem and just to simplify the solution. Now, I've spoken to Linda Volz, who is a member of the Labor Party, who voted, well, it's a bit complicated. When the legislation was returned to our House, the provision was embedded in the legislation, so we were voting for an amendment to remove it, ironically. So our amendment was actually to reverse the Lower House amendment. But Linda was voting with us on that matter, and she's very interested in potentially co-sponsoring an amendment to change it. But we've decided that the best approach really is going to be to work with the ministers to build knowledge and understanding before making a big foray back into the issue again. It was an error of information, and so we need to go back and correct that matter. So it may not happen as quickly as people would like, but I'm hoping that it can happen potentially some good news this year. But bear in mind that we are going to have to build a very strong coalition behind the scenes. I think the stories that you're telling are so valuable in terms of enhancing people's understanding. I don't think that the people who inflicted this situation did so for any reason other than confusion and being totally misled and hijacked at the time. So that's why I am optimistic that we can get this reversed. I equally understand the importance of New South Wales not having legislation affecting a third of Australia that then contaminates the legislation of all of the other states, and that gives this issue a particular area of urgency. So can I just repeat my message of thanking you for your hopes and your dreams. They're the best thing I can do as a Member of Parliament is to support that. And I know many of you already have children, congratulations, and many of you are aspiring, and I can only wish you every success and hope to play a part in ensuring the government eases your way along the path rather than inhibiting it, which unfortunately is what's happening at the moment. So thank you very much.
So the first thing I'm going to say is, what is the rail gauge in Victoria? Does anyone know? Anyone remember the old imperial measurement? 5'3". What's the rail gauge in New South Wales? 4'8.5". What's it in Queensland? 3'6". And what's it in South Australia? A mix of all of those. And I say this because that's a 19th century legacy that we're still living. And whether we like it or not, and I'm going to be critical of New South Wales only because it's a state. and all our states have failed us, in my view. And that's by default. The Commonwealth has failed us. But we now have 9 systems of law about surrogacy in Australia. Just count them up, 8 states and territories, plus the Commonwealth. And the Commonwealth has a little bit to do with surrogacy with the Family Law Act and the Australian Citizenship Act. So I'm just going to go briefly through each of the states and territories. Who's here from the Northern Territory? No one. Well, the people of the Northern Territory are lucky. Now this is fairly bizarre. By default, there are no laws in the Northern Territory concerning surrogacy, so it's perfectly legal to engage in commercial surrogacy in the Northern Territory, but you can't engage in gestational surrogacy because you have to involve an IVF clinic, and the clinic there, of course, is bound by the National Health and Medical Research Council ethical guidelines, which says thou shalt not engage in commercial surrogacy. So bizarrely, the type of surrogacy you can engage in Darwin is traditional surrogacy. So you can find a woman, pay her $10,000 or whatever it is, and have a baby, but you can't actually be called the parents. Anyone here from WA? A few people from WA. Well, aren't you lucky? You have a state regulator, which I think just makes it incredibly difficult, and I've had this discussion yesterday. I think it's far too difficult in WA. Straight people, couples can engage in altruistic surrogacy. If you're single and male, forget it. If you're single and female, it's okay. If you're a lesbian couple, forget it. If you're a gay couple, forget it. The good thing about WA is that you can go overseas and you're not going to be prosecuted for going to India or the US or Thailand or Ukraine or wherever else it's offered. Anyone here from South Australia? Okay, well, you've got to be straight in South Australia to engage in surrogacy, and it has to be altruistic. No singles need apply, but you don't have a problem with going overseas. Anyone here from Tasmania? Good luck. Currently banned within South Australia. You can go overseas, but what we know about Tasmania is there are bills floating around. Sam gave evidence. I gave evidence July last year. God only knows when it's actually going to be enacted and what form it's going to take. The current form that committee members were saying to me in July last year was, well, we're going to have a magistrate. Well, we think it should be a family court judge until I pointed out that there's a problem. That's a Commonwealth court, rather technical. States can't give Commonwealth jurisdiction. We have a state magistrate ticking off on the process before it can start, similar to that in WA and Victoria, but with a magistrate instead of an authority. Anyone from Victoria? Well, for those of you who are going overseas, congratulations. Victoria at least got rid of those silly rules about banning overseas commercial surrogacy. For those of you who have the misfortune of trying altruistic surrogacy in Victoria, well, I'm sorry for you. I've had many clients from Victoria who said, look, the red tape here, the cost here, the delay here, it's all ridiculous. I'd rather just pay some money and go overseas. I'm looking at the US, I'm looking at India. And I can't blame them. I think it is far, far too difficult. There is nothing quite like turning up at a conference as I did in November last year and hearing IVF owners whinge, moan and complain to the regulatory panel member who was there about how difficult it was to try and do surrogacy in Victoria. Anyone here from the ACT? Well, isn't that ironic? One person from the ACT, because in the ACT, you've got to be a couple. You must be a couple. It doesn't matter what type of couple, but you've got to be a couple. And the surrogate has to be a couple. You can't have a single surrogate. Anyone here from New South Wales? Well, you may be surprised to learn that you're not the only state that bans overseas commercial surrogacy, because the ACT has done so since 2004. New South Wales, you're newbies at this. Queensland, we're the pioneers. We're the pioneers in banning people from going overseas. We banned everyone on surrogacy, and that was from 1988. 20 years of it. And so when Queensland decided it was going to have altruistic surrogacy, we had this bizarre spectacle of two bills, the opposition bill and the government bill, absolutely identical, except of course the LNP said, well, we don't want gays and lesbians or singles, they're out. And it may well be the case post-election that they're going to be out. I've heard Campbell Newman say otherwise, but I must say he's got a super majority, he's got super power, and he's indicated in a number of ways of how he's powerfully affecting LGBT issues in Queensland. So it's illegal if you're in Queensland, it's illegal if you're in New South Wales, it's illegal in the ACT to go overseas. And there are different offences in each jurisdiction, and they can have different results. The misfortune for those from New South Wales and the ACT is there's no time limit. You can be prosecuted from here to eternity for the offence you committed. Queensland, you'll be pleased to know, sunny Queensland, we're a year. But it's not a year from, there's different offences, and in effect it might mean from the time you sign up to the time you have your baby, it might be a year after your baby's born before the last time limit applies. Exciting stuff, isn't it? And if you're a lawyer like me who has clients in different states, and you might be amazed to know that surrogates don't all live in the one state where the intended parents live. So you might have intended parents, I don't know, for example, living on one side, this is a hypothetical example, but not far from the truth, living on one side of Griffith Street, Coolangatta, and the surrogate living on the other side of Griffith Street, now Tweed Heads, literally about half the distance from here to that wall away, and we've got to comply with two sets of legislation which are incompatible, and you hear the politicians and they say, oh, they're exactly the same. No. As one client of mine once said famously, it's exactly the same but different. I had some problem with that woolly thing. He wasn't a surrogacy client, I might say. But that describes the state of law. Exactly the same but different. The politicians would have you believe it's the same. It's not, and it's very difficult. And I must say, it is just like walking through a minefield. For those of you who go overseas, clients of mine have moved from Queensland to Darwin, from Queensland to Victoria, from New South Wales to Victoria, from Queensland to Perth, from the ACT to Victoria, so that they're not committing offences. They've got to do this to do it legally. And it's just, I must say, it's just weird. I can't understand why it's such a good idea for people to move from one state to another, why it does wonders for our economy. I can't understand why it's okay to have women in the United States and India providing commercial surrogacy services, but not in Australia. I just don't get it. Are our women so much more valuable than women in the United States? You follow the logic through. Are our women to be protected more than those in the United States or India? If we're serious about saying that commercial surrogacy is an evil, then it should just be banned completely. But of course we know that won't work, because being a parent, I'm privileged to be a parent, and I could never have imagined a day in my life without having been a parent. It's an innate thing. The US Supreme Court described it as a fundamental human right to procreate. That's what we believe in. And the reality is, if you have this 100% ban, then it's all going to, people are still going to do it. And it's much better to regulate it. How am I going for time?
5 minutes.
I've got 5 minutes, okay. So I want to talk briefly about bringing babies home. Rule number 1, always get legal advice here from someone who knows what they're doing. Of course I'm spruiking myself, but there you go. Most lawyers don't know about surrogacy. They don't. They wouldn't have the faintest what it meant. Number 2, always get advice from a migration agent. It's really basic. If I'm going to go to a country on the other side of the world and I'm going to spend a bucket load of money, then don't you think I'd be smart enough to get some advice from someone who knows what they're doing? It's just a no-brainer. My good friend Raymond Dune is there, who is the migration agent I trust, and he, in the words of King Bergman, always gets the baby home. And I say that because, hey, it's easy to screw up.
Is he based in Queensland?
Sydney. And I was once told I wouldn't know about Tasmanian law, because I'm not in Tasmania. Well, there's a thing called the internet. And I wouldn't be able to talk to Tasmanian clients because I couldn't see them. There was a thing called the telephone and Skype. And it's one of those things that you know, I got into this surrogacy advice because I've acted for gay and lesbian clients for 20 years. And I started to, you know, despite their best efforts, gay clients were never able to have children. They try every Saturday night. And my lesbian clients, well, they you know, occasionally they would need to engage in surrogacy as well. But bringing your baby home can be fraught with difficulty. The Australian Citizenship Act says that if there is a parent who is an Australian citizen who then has a child, then that child is entitled to Australian citizenship. And so this is what we call citizenship by descent. But the term parent and the term child are very, very poorly defined. If you're a heterosexual couple and you're having sex in the back of the Commodore on a Saturday night, no question you're the parent and you have a child from it. There's no question that each of you are the parents of a child. But if there's a bit of you and a bit of the other, or maybe from someone else, and you put them in a bit of glass, and then you put them in the body of a third person, and then voila, a child comes, who is the parent in that situation? And the Department of Immigration would have you believe you need DNA. And we know the reality when you go to India, the Department of Immigration and Citizenship says the DNA test applies. That's not the law. The law is a parent is someone who is seen to be in the role of a parent. And we know that because that's what the full court, the federal court, said back in 2010. And there were two cases. One was the Chinese man, or the Australian man, who took up with the Chinese woman, knowing that she was pregnant. She lived in the PRC, knowing she was pregnant to another man, and said, "Darling, I'm yours. Let's marry. I'll bring up the child as mine." And so his name went on the birth certificate, obviously after the wedding. And of course the department said, well, there's no DNA link, so you can't be a parent. Full court of federal court said, following the US Supreme Court, no, that's not right. If he's not the parent, who is? Great phrase, if he's not the parent, who is? The second one was the woman from Fiji. Mum said to her, well, you know, Bob is your dad. Bob was an Australian. Bob got blood tests done because it was pre-DNA, same type of blood. You know where this is going. Bob went home to Sydney and said to his wife, "Hey, darling, guess what? I've had a baby by another woman in Fiji." They stayed together, amazingly. He paid child support. He would visit his daughter in Fiji. His wife would visit the daughter. His children in Sydney would visit their half-sister. And so she's 30 and she says, and she'd come over as well, and of course she's 30 and she's saying, well, I want to join my father, my stepmother and my siblings, because they're my only siblings, in Sydney. Guess what? He wasn't dad. Another man, believed to be Australian, appears to have been the father. But of course the federal court said, in every sense, he's dad. If he's not the parent, who is? He's done everything by this child. He's paid child support. He's acknowledged he's the child. He had to go and tell his wife he'd fathered a child. Lucky him, that must have been a great day in their marriage. And yet we move forward to last year and we think, okay, that's the state of the law. Move forward to last year, we had a series of cases involving surrogacy from Thailand. Anyone done that? Surrogacy from Thailand? Okay. General advice, don't. But in any case, surrogacy in Thailand. And 4 of those cases on the 30th of June last year were decided by Justice Watts in the Family Court in Sydney. 2 of them were from Queensland and 2 were from New South Wales. The Queensland cases, you'll remember, His Honour referred the parties to the DPP for prosecution of the Queensland laws. Now, as I understand it, they were never prosecuted. In terms of the New South Wales couples, he grudgingly admitted that they'd signed up before the 1st of March 2011, so what they did was legal. But then he said, who's a parent? And he didn't actually, he'd seen the federal court case, but he didn't follow through the reasoning of the federal court. What His Honour said was, I'm not making a finding. His Honour's been critical of me because I've said he made a finding. So I'm not saying His Honour found this. I'm saying His Honour questioned it. And in respect of the Queensland couples, he said, well, what they did was illegal. The law doesn't honour people to do illegal acts. For example, if you murder your parents, you can't inherit from them. And so, therefore, if this man has done this illegal act, he may not be a parent. Now, if you think of the Australian Citizenship Act, that might therefore bring citizenship into question. The New South Wales cases, he said, wait on, this may not be directly relevant because it wasn't intended with surrogacy in mind, but the Status of Children Act in New South Wales and its similar identical legislation on this point in Victoria and Queensland amongst others says, well, if you get donor sperm and you get a donor egg, then that woman's the parent. And of course, her partner or her lesbian partner or her husband. So that would mean that the surrogate is the parent, not the intended parents. So again, the issue of citizenship. The last thing I want to leave you with, or the last two things, so I'm going to run out of time, Richard. The last two things I want to leave you with are these. What His Honour highlighted was that anyone who engages in overseas surrogacy is not actually, or may not be, a parent of the child back here. And you go, oh, so what? What is that? What difference does it make? We've got a little bundle of joy, that's fantastic. Well, it shouldn't make a difference in dealing with schools and hospitals. It shouldn't. But what it might do is have an impact on you if you die and you don't have a will, or your will says to my children, well, sorry, this one isn't a child because it's not, as a matter of law, your child. You have disinherited your child. Disaster. So I'm certainly advising my clients how to have specific wills and accompanying documents to identify, to protect the children's interests at the end of it. The last thing I want to talk about is the Hague Convention. The Hague is a standing committee of international conventions. And for example, there's a Hague Convention, it's on private international law. We've got a Hague Convention on international child abduction. We've seen from the Hague case in Queensland that's been all over the media. There's a Hague Convention on inter-country adoption, and isn't that a success? Why I say that? Because currently the Hague is looking at having a convention dealing with international surrogacy. And here are some parameters about it, where it's going at the moment. I'm on a committee of the American Bar trying to put the American Bar's position about it. I don't know why they chose an Australian, maybe I'm a loudmouth, I don't know. But the first is paramount interest of the child. You go, okay, well that might be okay. It might be okay. That sort of sounds on the face of it okay. Number two, you'll love this one, surrogacy is like adoption. And I thought, okay, well, I think there's a bit of difference. You know, one sort of starts from here and the other you bring in. There's a fundamental difference between the two processes. And then I thought, well, let's assume they're right. What's their record on running adoption internationally? If we're going to have an international convention that runs anything like the way adoption is run, it's going to be completely buggered up. There's no question about it. Oh, and the third element that you'll just love, that intended parents have to qualify. Now, what do they have to qualify? I don't know, but I can guarantee one thing, same-sex couples will be out. That there'll be all countries that exclude. This convention will not cover commercial surrogacy. For commercial surrogacy to occur, there'll have to be bilateral treaties as well. It's anticipated that The Hague will have its convention in place in 2 to 3 years, and you'll be absolutely delighted to know that the Australian government, our Australian government, thinks that the Hague Convention is a wonderful thing and should happen now. Now, I think it will be a disaster as it's currently proposed, and I will do everything I can to oppose it. I'm currently setting up meetings with politicians. Whether they listen to me, I'm just a plain old lawyer. I don't know. Certainly when Queensland was re-legislating its Surrogacy Act, no politician wanted to talk to me about the overseas ban on commercial surrogacy. They weren't interested. It was a non-issue. Both sides of politics had the same draft on that. There was unanimity within Queensland Parliament on that. They see it as fundamentally evil and wrong. And I don't see there's going to be much change north of the Tweed at this stage. I think I'm well and truly out of time. Thank you.
To preface my presentation, I must say that when I speak to Queensland families back home, I do deliberately schedule the speech for an evening function with alcohol and fried food to sort of distract from the complexity and many of the frustrations and distress that the regime has produced in Queensland. Now, I'm going to take a very practical approach this morning and try to draw some guidelines from the Queensland experience of altruistic surrogacy since the introduction of the Act in March 2010. We're all very proud of Stephen's work in the field, and really my focus is going to be on what you might consider as intended parents or surrogates, or the many supporters who are required to assist parties in the process. Now, as Stephen has mentioned, Queensland, how unusual, had the most draconian approach prior to 2010. Now, it is possible for families to enter into a surrogacy arrangement. Curiously, it need not be in writing, but it ought to be. Now, the policy adopted in Queensland is expressed to be the same as every other state that permits altruistic surrogacy, which is children's interests are the paramount consideration, that there is to be an approach of honesty and disclosure regarding a child's origin. Parliament has also seen fit to say that there is not to be any supremacy given to genetic contribution, so all families, and I think that's probably the only really kind thing that can be said about the legislation, other than it gets you a baby, is that everyone has access to the process, assuming of course they can find an incredibly obliging relative, friend or associate who will carry their child. Eligibility, must be 25, so you've got to have a few miles on you. A mother must, an intended female parent must be able to satisfy criteria of eligibility, and that's really social or medical need, which relates to an inability to conceive or to carry. Dads of themselves qualify. And the process is really about placing intended parents, and it may be one parent. A single man or woman is eligible, subject to satisfying other criteria, to become parents as if they always appeared on the register and were in fact the child's parents. Now, prior to embarking, and timing is crucial in this area of altruistic surrogacy, in everywhere really that it's contemplated, because it must all be in place prior to conducting any of the procedures. Now, I've been approached by clients who had started down the path informally without any type of advice, and then would like to turn that informal arrangement into a surrogacy arrangement and apply for parentage orders in the Queensland Children's Court. It is not possible to give a process that has not been conducted in accordance with the requirements, the legitimacy that you need by the end. Now, this is the aspect which you're all terribly familiar with, but as a lawyer it sort of makes you feel sick on the stomach, is that every aspect of a surrogacy arrangement is unenforceable. It's generally speaking, a written document that you labour over, that you think, I've got to protect my client's interests, I have to think of the child, but really at the end of the day it is entirely unenforceable, and consent is a fundamental aspect of it, and consent after the baby comes remains a very important feature. Now, of course, it must be for entirely without payment, and payment is very broadly defined, and I think you would attract a great deal of difficulty to your family if you were to try and get around those requirements at present, because it's very broadly construed. When contemplating surrogacy, naturally you think of the medical costs. You're required as the intended parent to meet all of the medical costs, all of the legal costs of the surrogate and her partner if she has one. But the other the Queensland Act specifically contemplates things like loss of earnings and the like, and in some sort of insurances. And everyone, of course, is thinking about health insurance. Be conscious, though, and this has happened to two of my families, the surrogate mother's health has broken down during the process, and in both of those cases they're yet to have a baby, and one surrogate has decided that she simply can't continue. She has her own family to look after and just can't continue with the procedures, which are gruelling. So that, of course, then she approached me, and I'm not a personal injury specialist, and said, well, what can I do? It's kind of aggravated my back complaint. I had a work injury. You know, everyone has a long and tortuous story bringing them to the door. And thankfully, I had said to them, you know, reading no doubt Stephen's articles, I said, oh, thank God, we've got some insurance. We've got disability insurance. Well, that was a miraculous thing. Now, there are risks in this, and the first family that I assisted, the female intended parent in that case said, well, this is our option of last resort. And it was a very clanging phrase to hear, and I think of it often, because this is a risky procedure. The benefits are so spectacular, and I don't want to be... This conference seems to me to have an air of a party and a rally. A lawyer presentation is very depressing, I accept that. But I'm just going to... and really, they should have gin at morning tea time. But I will, because it's my job, rattle off all of the risks that apply to everyone in this thing. So the risk for their birth parents, it really applies wherever you are, even though, as our railway engineer Stephen says, it's all different but same. So the intended parents can withdraw as well, meaning that the birth parents who really were not planning an addition to their family might be left with the care of that child. And then they're in the excruciating position of deciding whether they will in fact keep that child. And in Queensland, if they place the child for adoption, despite what a lot of people like to do with their little inter-family things, it is really not possible to have a binding adoption in Queensland that you choose your adoptive parents. That child, this precious surrogate child, surrogacy arrangement child, which is the definition in the Act, will, if the law is followed, be placed in the general pool of adoption. And there's a cooling off period for the birth mother to change her mind, but then that child might go anywhere. Now, I know of families who are keeping their babies that the intended parents don't want. What is the status of that child? Who will have the rights and obligations and responsibilities to that child? The other risk for the birth parents is that there'll be child support payable potentially if the intended parents won't take the child, or, for example, if there's a separation between the birth parents who have been left with the child that the intended parents will no longer take. And it might be that the surrogate decides not to give the child to the intended parent, so it doesn't always come about in that way, that there'll be child support payable by the biological father, depending upon, of course, the source of that genetic material. Risk to the mother's health. There's also a big time lag issue. Now, that is specific to the legislation. The birth parents naturally remain the parents of the child in its full force of the law for at least 28 days and up to 6 months and possibly longer until an application for parentage orders is made. There'll be medical care needed, for example, even in just a normal delivery, but there might be cases where ill health of the parties, and in particular the baby, makes that more difficult. The risk to the birth parents is that there can be an application for a discharge order. Now, this is in exceptional circumstances, and it's the birth parents or the intended parents or one of them or the Attorney General who might intervene and say the parentage order ought to be discharged. Now, it's for any exceptional circumstance or if there's been a commercial payment. So now, that, to my knowledge, that provision has not been relied upon so far. And as Stephen mentioned, those poor families who were referred to the Department of Public Prosecutions, it would appear, quite sensibly, that the police, having many other things to do, are not pressing charges against them. But what I say when speaking about family law generally and surrogacy included is that it's an area of fashion. It's not currently fashionable to pursue these poor families. It might be. And so you need to be conscious of that. So, of course, one of the major risks that applies for everyone, even if you get a parentage order, so that is like the most precious jewel for intended parents to have, as though they were always the parents. If they can't get the parentage orders, one, because they didn't adopt the altruistic program, two, they shot off overseas, or for some other reason, for example, consent by one of the birth parents was not provided in the end, everyone in that scenario is still subject, like every other parent in Australia, to the provisions of the Family Law Act, which means, for example, you can be a set of intended parents or parent, you have your child with you, your procedure's magnificent, everything's being done, the surrogate or her partner or another person interested in the child's care, welfare and development is able to apply for parenting orders, which are different orders from parentage orders. So parentage is really about the status of parent. And again, that is an oddly defined, loosely defined concept. But parenting is basically about having a role in the child's life. Now, one would hope, and that you contemplated within your surrogacy arrangement, what role the birth parents will have in the child's life. But, and you'll be very surprised that I say this as a family lawyer, sometimes those agreements break down. And if they do, then you're within the province of the family court, who will make an assessment about is it in the child's best interest to have a relationship with that child. Now, again, this I think reflects trends in fashion in family law, that biological parenting used to absolutely trump the day. And so there would always be an attempt to preserve the child's relationship with a biological parent of any stamp or origin. Subject to, of course, was it in the child's best interest? Now, so the Family Law Act was very significantly amended in 2006, and whilst paramountcy of the child's best interests has remained, there are a number of mandatory considerations that the court will now have to examine about what time people should have with children. And biology does no longer has quite the sway that it used to. So broader than surrogacy, families are so complex and diverse in Australia that there are now many applications before the court and that have been decided where people, for example, were in a relation, like step parents but not officially so, or lesbian or gay couples who've had children, or two sets of homosexual families who, in this case, the lesbians said, well, they were really just, one was providing sperm and they were just intended to be part of our friendship group. and my clients, the gay men, say that was not the deal at all. We were going to be their dads and part of the children's lives. Now that, of course, is not surrogacy, but I mention that case because basically everyone, you'll end up, if you get your precious baby, you will end up in the same system to which every other poor person in Australia is subject, and that's the family law courts, which will have what they can do to you is really quite extraordinary. So be conscious of that you're not going to be, even if you get precisely what you want, you are, I say to clients, well, you're in family court world now, and that is dark, that is a dark world. Now, but I don't ply them with alcohol as they're paying bills. So the risk for the intended parents will, of course, that the surrogate and her partner, if she has one, choose not to relinquish the child or consent to the parentage order. There's no control over decisions of conduct, and it's specifically set out in the legislation that the surrogate has every right that every other woman has to conduct her pregnancy as she wishes. Now that in itself, and that is why the mandatory counselling that must be undertaken prior to entering into the treatment process is so important for discussing these issues, because the sorts of issues that really, when you consider them, that have caused surrogates not to want to hand the child over in Queensland have been things like, you were lousy to me about the insurance and you chipped me about this, and really very minor issues that could, if more sensitively dealt with, could really have been addressed. So Queensland only requires a course of counselling at the beginning and then a separate counsellor to do a report at the end when the parentage orders are applied. But what you might want to consider is a commitment to a series of counselling sessions right throughout the pregnancy, post-pregnancy, and a suggestion that Michael Condon of QFG has made to us, and which we have adopted, is to also have broader family members included in the process, and that what grandparents think of the arrangement and best friends might really be of some assistance, because the community in which the child will find him or herself is going to be vital to how well the arrangement sticks. Now, the other practical thing, and again, you'll be shocked to know that lawyers' fees really are very expensive, is that I've had clients who not only are they, so not everyone is the perfect white middle class picture with heaps of money, and really they're just pursuing this avenue because it suits them. Lots of people are borrowing the money against their houses, and they need to, so while lawyers hate a quote and love an estimate, I think you might want to consider approaching on the basis, well, this is my broadest outline for medical costs and insurance and counselling programs, etc. And this is my, for example, what if, I'd have a factor in there if there's difficulties regarding consent or the ability to, relationships are fragile, I don't need to point that out. Finding people, and then they'll be borrowing that. So you need to, and it's a long, even in Queensland, which it's supposed to be quite speedy and efficient. We pride ourselves on that. It's really not. It's really quite a slow process, and so there's a very long path to take there. Now, medical emergencies, again, I've mentioned that. Contemplate that in the counselling program, or if that's not mandated, where you are, think about what are we going to do, what are our views about a range of issues, how forceful would any, attempts to save everyone be, what is the attitude to blood transfusion, a whole range of things that I think in the excitement and the strain of it all might be overlooked, and that you really will have to explore, at least for a period of time, what are each set of parents' attitudes about a host of issues, because there might be at least 6 months and possibly even longer where there'll need to be decisions made. And given the policy of openness that is enshrined in the legislation, these people are going to be in your life for a very long time, and well, certainly the ones that I've had involvement with, and I'd be very interested in your views about that. Everyone at the start is contemplating that the child will of course be told, but that there'll be some integration of family life, that they'll be sort of like aunts and uncles incorporated into family events. And so where are the children going? Now, of course, none of this is enforceable, but it's like how people feel that the other side is going to respond to these issues can be critical in making sure that the baby is handed over successfully and that everyone feels comfortable with the process. So really that's that there are issues about confidentiality, certainly in Queensland, but the states that permit altruistic surrogacy, whilst differently worded, all do have legislation about it. So it's not a matter of right that the intended parents will be able to, and certainly it won't be their decision about what medical care should or shouldn't be given to the baby or remain the birth parents for a period of time. So knowing lawyers' passions for PowerPoints, there's a great deal more information in my paper which Sam will make available to you. But really, in summary, the earlier that that appropriate advice from counselling and from legal aspects is engaged, the broader your consideration of a range of practical issues which aren't necessarily suggested by the legislation or the process will assist you. And it's important because this is an unusual field in that as a lawyer we've got to sign off a certificate as part of the parentage order application that says not just I gave you this advice about 52 items that are set out, but that you appeared to understand it. And so that really you need to come to whoever you engage with your own set of concerns and then be guided in that discussion by concerns that have arisen in other matters and by the broader community, and take the support I think that's offered here, because it's absolutely astonishing to me how every case generates a different set of concerns, and that if you really try and factor in all of those things, we might get the result that everyone longs for. Thank you very much.
Well, when Sam asked me to speak on rate tips and bureaucracy, and the word my colleague used here, I was thinking a lot as to what should I speak, because honestly speaking, there are two aspects to bureaucracy in India. And one should understand the fact that doing business is very bureaucratic, but as a consumer, which all of you fall under the category of consumers because you are the one who comes to India and consumes the services. So hence, as far as bureaucracy is concerned, I feel let us first understand and get this doubt cleared from our minds, that you as a consumer who would come to India to avail of any of the services of the clinics or the hospitals would face the most minimum bureaucratic hurdles. And I can list out here not more than 2 instances where you come across with the government of India. Well, if you want to set up a clinic or a business in India, then I'm sorry, my friends. Like, yes, we do have a hierarchy of bureaucracy which we have inherited from the Britishers. They have left, but the bureaucracy is still there. And we take pride in that. Nonetheless, but consumer is a king, and I think so we have all realized it. And I can see so many people here who have come to India, who have experienced the Indian scenario, and I'm sure they can vouch for it. Now, as of now, Indian government has not enacted any law on surrogacy. Now, well, it's a double-edged sword here. You know, on one hand, the governments of European countries, government of Australia, they all want India to enact a law so that they alleged, the exploitation angle, which a lot of people fear about, can be taken care. But nevertheless, the industry has done self-regulation. The clinics and the hospitals have completely shown the keen interest in following the ICMR guidelines, which are in a way very good guidelines. So far, no bureaucracy because no government law, and the government interference is minimal. Again, one more reason why the government doesn't want to interfere at the moment is primarily because medical tourism is booming in India. Surrogacy is just one of the many aspects of medical tourism. we are seeing a lot of patients coming from Europe for other treatments as well. So they have identified this as a sunrise industry after IT industry. So hence the government doesn't really want to regulate it as of now. But yes, I'm going to speak about the legislation, which will definitely be part of the government agenda. Now, involvement of government at the best at 3 levels. One is the birth certificate, foreign registration office, FRRO or exit permit, and the visa. Now, I'm not a visa expert, but I also know that one thing for the sure fact that whoever comes to India, I don't think they have so much of problem in getting the visa from the government of India. Now, there are various types of visas, and I think so. Many of you would come on a tourist visa, which I would always advise because it's much easier to get a tourist visa than a medical visa. Now, yesterday someone mentioned about surrogacy visa. Well, I'm not aware about that category as of now. I don't think so. The government has officially categorized any visa as a surrogacy visa. It is broadly a medical visa. And if you come on a medical visa, there may be restrictions because you may have to disclose some facts which you may be uncomfortable in disclosing. You may have to disclose some locations. It's a very new area. Okay, a lot of people come to India on tourist visas, and going and meeting a doctor is part of your tourist activity. Trust me, there's absolutely nothing stopping you from going to any hospital, any clinic, and you can very well categorize this as a tourist activity. So no legal problems. Now the birth certificate, very, very important aspect for all the parents, single parents, couples, gay parents. Now it's very easy, and you may think I'm just saying this, but I'm sure you know this, that most of the packages which the clinics offer, the birth certificate is part of it. Which means that you really don't have to go and stand in a queue to get the birth certificate. The way it works is the birth certificate is issued under the Births and Deaths Registration Act 1969. Now it is the job of the clinic to intimate the municipality about the birth certificate. It is not your job. Okay? The law has been specifically given the responsibility upon intimation of the birth certificate upon the hospital. So every week, every baby which is born in every hospital in India has to intimate about the birth to the nearest municipality. So you really don't have to get into that. The hospital does it, the superintendent of the hospital does it, he seals it, he signs a paper, and there is a register which goes every week to the local municipal office where the concerned clerk enters the data in the register, and you can go and issue the birth certificate at any counter, computerized counters, and it is just a matter of 50 Indian rupees, which is less than $1. Today the dollar is 54, Aussie dollar is 54 to a rupee, so Indian 50 rupees is less than that. So it's so simple. And again, the second point on this, the name of the intended parent, that is genetic parents, appear on the birth certificate. If you are a single, then the name of the other spouse remains blank. Now here, there are some differences. In some cities, they put the name of the donor, but in Mumbai, from where I come, the other spouse name remains blank. We don't put any name. It's just the name. If it is a gestational surrogacy, both the parents have contributed genetically, then your both name comes as parents on the birth certificate. The form has to be filled in. It's just very simple form. It's a printed form which is available. It is downloadable on the websites, and the hospital has to know exact details. So before the hospital sends the register to the municipality, you have to fill in a form, give the hospital exact name with proper grammar, and because we come across a lot of clients who give us a name in their original, in their mother tongue, which becomes very difficult for us to understand. So hence the clarity is requested, and if you give the exact name, fill in the form properly, or take the assistance of the hospital staff, I think so it becomes very easy for the people to register the birth certificate. Now, as per the Act, it is very difficult to change the birth certificate. Like I have mentioned, there are only 2 cases where the birth certificate can be changed. One is in the case of a spelling mistake and other grammatical errors. And for that as well, you need an affidavit, which means you have to swear it in front of a notary or go to a magistrate and stand before him and swear the affidavit, and then go to the municipality, and then they will issue a corrected or amended birth certificate. So it is extremely difficult, so be very careful, give the proper details, fill in the form in legible handwriting so that the government officials really don't have a problem in understanding your handwriting. Now another issue is the Foreigner Registration Office. Under the Foreigners Act in India, every foreigner who comes has to register. Now at the time of immigration, automatically you register because you present your papers so they understand. But your baby is born in India, and hence when you come to pick up the baby baby has not cleared the immigration. So hence you have to go to the Foreigner Registration Office to register the baby. And hence it is again a very simple procedure. I say it's simple because again it's part of the packages that you are given. Like for example, my package includes these services as well. So it's something which is done by the lawyers or the clinic staff or the hospital staff, and it is a very routine procedure. Like someone mentioned yesterday about some of the cases which have gone problematic, like the French case, Dr. Sudhir Ajja mentioned about that. But I think so it's one of the cases, and I have done more than 300 cases in last 6 years for all the clinics in Mumbai. I have to work for almost 80% of the clinics in Mumbai, and in my understanding, not a single case has got stuck or stranded. These are the surrogacy has been done in India since last 10 years, from 2002 when the first ICMR draft came. And in that, if you see the period of last 10 years, only 3 cases, the average is pretty good. I don't think so 3 cases in 10 years is a bad average. And if you go to the Foreigner Registration Office with the following documents, no one will make you wait for more than 2 hours. The 2 hours is only for the queue, because there are other parents like you who have come there. So in Mumbai, from where I come, there is a lounge which is being run by Thomas Cook for parents like you who come, because the Mumbai police who runs the FRRO has probably understood the importance of making your life a little comfortable. So hence they have outsourced the initial screening to Thomas Cook. I'm sure you must have heard this name. And hence it is very easy. There is a counter. Once you go, there's a beautiful lady who sits there. She checks all your papers. If all the papers are in fine position, then she will ask you to go inside the lounge. The lounge has got 5 terminals where you have to fill in an online form. By the time you fill in the form, the others are there inside the police officer's cabin. There are 5 to 6 cabins where they are given the tokens. As soon as your token is called out, by the time you go inside, the fellow already has your form online. So he will just verify your passports. He will check, he will tally your pictures on the passport, he will see the baby, he will see the tickets that you have taken, he will see the temporary travel documents that your embassy has given, and if everything is in place, he will just put one small blue color stamp. And only 2 hours, that's it. It's not much, trust me. These are the documents. Now, the police is little strict. So if you have all these documents in place, mind well that this is not an exhaustive list, because the rationale is that the police officer has to get convinced about your authenticity. So there is really no list of documents. This is the general documents that we have culled out of our experience in dealing with surrogacy cases. Now some of you must have got the list of documents, but I feel that you should rely on the fact there is only simple logic. He will ask you all the papers which would identify your status, which means your passport, your baby's photographs, your hospital records, your surrogacy contract, your birth certificates. These are the very important documents. And in my experience, 99.99% of the cases, all of you come extremely well prepared, because it's really not a problem, because they all are very conscious about the fact that you have to sit before a police officer for 5 minutes. Well, they are not very threatening at all, because it's a FRRO, they are not the ones with the guns. So now, just before I came here, I had a call from Cochin, that is the southern city of Kerala. And the gentleman there was again a foreign national, a single parent. and he was very frantically calling me, and he was asking me whether I would get the FRRO clearance from the Cochin, and he said I had gone there and I could not convince the fellow that this is a surrogacy process. So that makes me wonder that surrogacy is restricted only to few of the major cities in country, and hence the FRRO offices in these countries like Delhi, Mumbai, Chennai and Bangalore, they all know what surrogacy is. So they have been sensitized. The doctors have taken the pains of going and meeting the officers, and they have sensitized them, and they understand what is the process of surrogacy. They understand what are the intended parents. They understand the language of the contract. But there are still some cities who are new to surrogacy. India is a very big country, and it has got vast resources, and hence there are small cities which have excellent medical facilities as well. But unfortunately, the government support does not come in these cities because it is still restricted to the major metros. And hence, before selecting a clinic, I would always advise you to look at the metros first, because that is where the convenience is, and that is where the hassle is very, very less. And hence,